I've never been sued, I've come close. Well, actually, that guy that wrote me the letter, the guy in Benton used to write me a letter on toilet paper. It was unused, which made it all okay. But anyway, and he said he was going to sue me for $1 billion, but it never worked out. But imagine if you get sued, probably the last thing you think about at night, the first thing every morning. And people like Glenn Langley, and we'll have, is Juliana plan on coming on Thursday? We've got some of the experts in North Louisiana, and it's like, when you get served with something, these are the people you need to talk to, and it's like, this is solid gold, what you're going to hear for the next little while. And we're honored that Glenn made himself available to come teach tonight, and after Glenn is through, we'll take a little short break, and then we'll come back and give you some statutory updates, search and seizure, and some other things, and answer some questions. We got a good sovereign citizen question. Everybody look at the big hole right here. There's not a good answer on sovereign citizen situation, but we're going to discuss them in a little while. But if you will, put your hands together for Mr. Glenn Langley, attorney at law.
Thank you, Judge. How many of you have gone through the academy and listened to our little song and dance while we were at the academy? Show of hands there. Okay, we've got one or two, so I'm not going to bore but one or two of you. I'm going to go back and we're going to talk about civil liability, which is near and dear to your hearts, as the judge talked about, and then I'm going to try to save a little time for questions. I'm going to cover as much as I can. You understand what torts are and what civil and versus criminal is. Civil is when somebody gets sued for damages or for some other types of remedies, but we're basically concerned about suits for damages here, versus the criminal action, which is when you lock somebody up and they get prosecuted in the criminal court. We're talking about civil action here. We all know, and it's no secret, that law enforcement is under attack all across the board. There are organized attacks both in the streets, in the legislatures, and in the courts. And these attacks come in a lot of different forms. And we're going to talk about how they're doing it, how they are trying to attack the best defense that law enforcement has to civil liability suits. Now, we all heard in the academy when we went through that we have to protect these civil rights of people. We all have civil rights as citizens. The first 10 amendments of the Constitution list all the rights that the Constitution guarantees us. And when one violates these rights, what happened before the Civil Rights Act was that there were certain things, either the person was released or the evidence that was gathered in violation of their civil rights, their Fourth Amendment rights, for example, or if the violation was excessive force, the evidence that was gathered in response to that violation of their civil rights was excluded. So that was the exclusionary rule. And then Congress thought, what we really ought to do is give these people a right of action to sue the person who violated the civil rights of this particular individual. And that's when the Civil Rights Act came into being. And the Civil Rights Act, what you hear as a 1983 Act, says, 1983 says, every person who, under color of any statute, meaning a person like yourself who wears a badge, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction of the United States to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws. Any person who does that shall be liable to the party injured in an action, in a suit in equity, at law, or other proper proceeding for redress. So you can see that if you violate somebody's civil rights, they now have a civil cause of action for damages. Now, that's pretty extreme because when you're out there on patrol or you're in a correction setting, you don't have a lawyer in your pocket, you don't have the time to pick up a phone and call your lawyer and ask them if it's okay if you do this. Most of these things are under what you've heard as exigent circumstances. So you got to make the best choice you can. The courts realized this pretty soon after the 1983 statute was enacted, and they developed a doctrine called qualified immunity. Qualified immunity is the defense that we use in defending these lawsuits that are filed against law enforcement. Qualified immunity very simply says that when a violation of somebody's civil rights is the basis for a lawsuit, qualified immunity shields government officials performing discretionary functions. Do I arrest them or don't I arrest them? Do I handcuff them or don't I handcuff them? How much force should I use in this particular situation? Is this complaint by a prisoner something that I need to refer to a doctor, or do I just simply write him up and wait to the next medical call? Those kinds of discretionary functions. So qualified immunity shields a government official performing discretionary functions from liability unless their conduct violates clearly established statutory or constitutional rights of which a reasonable person would have known. Okay? It's pretty powerful stuff. So basically what it says is, if you make a mistake, then as long as the mistake isn't of a nature that any law enforcement officer would have known, then that mistake is not going to be the basis for liability. So is there a violation of the constitutional rights? You've seen those little charts. Is there a violation? If yes, then was that violation a violation of clearly established statutory law? If yes, then there's liability. If no, then qualified immunity protects you. If there was no violation of the constitutional right, then you don't have anything to worry about. Okay, so if you acted reasonably in a search and seizure situation, and of course others will talk about that tonight, but if there's no violation of the constitutional rights, then there's no civil liability that attaches. So that's pretty clear. Now, you think, well, Glenn, why are you here? And you're going to be here for 45 minutes or an hour talking about something that's pretty clear. Let's think about this. You know, I told you, and we talked about how law enforcement is under attack, and the defense of qualified immunity is one of the things that they're using to attack law enforcement. Qualified immunity is under attack in many of the circuits around this country. And what the attack is that these people are saying that how can there be a clearly established violation or non-violation of constitutional rights if you derail that at the qualified immunity stand. Okay? Let me see if I can illustrate it a little bit better. In Houston a few years ago, the city council got tired of people disrespecting law enforcement, so they passed this great ordinance that said, you know, if you cursed at a law enforcement officer, that was a misdemeanor, and you could be arrested for it. Clearly unconstitutional, no question about it. Violates the First Amendment of the Constitution. But, you know, as a law enforcement officer, you know, here's a duly passed ordinance by the city council, and people went out, and the first guy that enforced that statute, that ordinance, was, of course, immediately sued when the case was dismissed on constitutional grounds. So the police officer gets sued, and he says, look, here was something that was valid on its face. It was passed by the city council. It was an ordinance. It was part of my job to enforce the ordinances, and I'm entitled to qualified immunity. Court said, yeah, you're entitled to qualified immunity. The second police officer, after the decision came down that said this is an unconstitutional ordinance, the second police officer to get sued isn't entitled to qualified immunity, because at that point it has been clearly established that the law was unconstitutional, and therefore the act of the police officer in arresting somebody for exercising their First Amendment rights was a violation of the First Amendment rights. So it's that's why it's important for everybody here to show up at these things that we put on every year or so to talk about what the current state of the law is. Now, what we're going to talk about tonight is what the current state of the law is. It's hard to balance these things. Current state of the law is with respect not only to what you can and can't do out in the streets, but what the current state of the law is with respect to qualified immunity. So let's get back to talk about regular lawsuits. Okay, you get sued. The suit is going to be based upon state law, Article 2315 of the Civil Code, that says that anybody who creates or causes harm because of their own fault is going to be liable for the harm that he causes. That's under state law. And then under federal law, you're going to be sued under 1983, and I've already told you what 1983 says, that anybody who violates somebody's constitutional right under color of state law, under color of law, then that person is liable for those violations and constitutional rights. Now, fault can be either negligent, okay, you can just make a mistake, or it could be intentional, or there could be gross negligence. So under state tort law, if you just made a mistake and you ran a stop sign because you were not looking, is that negligence or is it intentional? It doesn't really matter. You've caused some harm, you were at fault, and so you're going to be liable. If in the law enforcement context, if you cause somebody some harm and you get sued for it, you're going to get sued, as I said, under state law for negligence or intentional acts, and you're going to get sued under federal law for violating that person's constitutional rights. The federal constitutional claims usually arise under the First, Fourth, Sixth, and Eighth Amendments to the Constitution. The first, of course, is restriction of freedom of speech and assembly. The Fourth Amendment is illegal search and seizure or excessive force. The Sixth Amendment is denial of access to the courts or denial of legal materials, almost always in a correction setting. And the Eighth Amendment is the conditions of confinement. And for those of you who work in the correction setting, that's the deliberate indifference to medical needs. You'll hear about deliberate indifference cases. Those are alleged to be violations of the Eighth Amendment, and there are 1983 claims there too. So Fourth Amendment, excessive force cases. You've heard of Tennessee versus Gardner. That case says that using deadly force to subdue an unarmed fleeing felon was unreasonable under the circumstances, under the Fourth Amendment. So you know that if someone is fleeing in general, you can't use deadly force to subdue them. If you did and you got sued under 1983, it would be difficult for anybody to defend because it's been clearly established under federal law, under a decisive case from the Supreme Court, that the use of that kind of force is unconstitutional. So you don't get qualified immunity under those circumstances. Just change the facts a little bit. Suppose that the fella is a known felon, you know he's armed and he's fleeing toward a schoolyard. Has it been clearly established that you can't use deadly force in that circumstance? Well, no, it hasn't. There have been some cases from different circuits, and generally those cases come out to say the totality of the circumstances is what the law enforcement officer has to consider under that particular exigent circumstance, and he has to decide at that point whether or not the use of force that he intends or the force that he intends to use to subdue the fleeing individual is reasonable under the circumstance and therefore not a violation of his, either not a violation of his Fourth Amendment rights, or if it is a violation, then it's a reasonable violation because he did it under those circumstances. He did it, made the best decision he could at the time. The courts have talked about, and there's language in all these cases that say, you don't carry a lawyer with you. Most of you are not lawyers. You're not expected to know every bit of the most current decisions on these circumstances, on these topics. You've got to make the best decision you can. And that's why in the definition that I read you a little bit earlier, and I'll read you again in a minute, it is the best decision that you can make at the time, and it has to be, to find there is liability, you have to find, or the court would have to find, that every reasonable law enforcement officer would have made a different decision than the law enforcement officer made there. So it has to be every reasonable law enforcement officer. Qualified immunity is a great defense. It's judge-made, so it can be changed by the courts at any particular time. And as I said, they're different. You understand, you've heard about the Fifth Circuit. There's circuits all over the country. The Fifth Circuit that sits in New Orleans is a federal court that those decisions control Texas and Louisiana, and so those, and Mississippi, so those decisions from the Fifth Circuit are the things that we have to go by, and then of course the Supreme Court, being supreme, they have the final word, but until the Supreme Court speaks, then we have to go by the decisions of the Fifth Circuit. So we look at what those federal courts have said, and we talk about whether or not those courts have clearly established the law as to what you can and cannot do. You have to forgive me, I'm trying to do this while holding this. I'll get this spiel down in just a second. Yeah, it might be the best thing to do.
See, I have the idea,
Yep.
and then these other guys.
They're going to execute for you. Well, while they're doing that, we're going to talk about a couple of different cases. The Fifth Circuit case that I want to talk to you about, first of all, the one that was decided in August of this year is Cole versus Hunter. In Cole versus Hunter, thank you, fellas. I don't know why we didn't think of this earlier.
He's gonna whine tonight, I can tell y'all that.
Did y'all hear that?
All right. Cole versus Hunter is a Fifth Circuit case that was decided August of 2019. It was an en banc decision, which means the entire court decided it. It was a decision, an opinion that wasn't authored by any particular judge. In that case, there was a juvenile in North Texas. There was a report that came in that said this juvenile was walking around a park and walking around a neighborhood with what appeared to be a firearm, holding a gun in his hand. The police officers arrived. The juvenile was walking around. Okay, that's all right. Thank you. Juvenile was walking around with the gun in his hand, had his arms crossed. There was a question, the record was a little bit unclear as to whether or not the police officers identified themselves as police officers. They did ask him to stop and put the gun down. He didn't do it. He sort of ignored them and wandered off. And then when they found him again, he kind of wandered through some hedges. When they found him again, he was holding the gun to his own head. At that point, one of the police officers did order him to put the gun down. When he refused to do it, they fired at him. He fired his gun, or his gun discharged, killing him, and then his family subsequently sued the police officers and the police department, saying that the actions that they took were unreasonable under the circumstances. The district court decided that they were entitled to qualified immunity because it had not been clearly established law that force, that kind of force, could not be used to subdue that subject. Now, the en banc decision from the Fifth Circuit reversed that and said they're not entitled to qualified immunity in that circumstance because the totality of the circumstances were that there was no threat to any member of the public by this individual. It wasn't in a schoolyard. He wasn't in a crowded environment. There was a question in their mind as to whether or not a warning had been given, and they questioned whether or not any law enforcement officer would have opened fire under those circumstances. The dissent said that it had never been decided that you couldn't use that kind of force, and that's the real test for whether or not qualified immunity was available. Now, a similar case was a decision that was made in 2013 in Georgia, and this is Corbett versus Vickers. A deputy ordered the entire family. He entered the home on a mistake. He was in the wrong home. They were searching for a felon, ordered everybody in the house, including this 4-year-old kid, to get on the floor and had his gun out. The family dog came out to see what was going on. The dog, by all accounts, didn't growl, didn't threaten the officer. But while the family was on the ground, the officer opened fire on the dog, shot at him several times, missed him every time, but managed to hit the 4-year-old, killing him with a ricocheted shot off the concrete floor. There was a question raised as to whether or not any law enforcement officer would have fired under those circumstances. And the court interestingly said that there were these facts, under these unique facts of this case, there was no case capable of clearly establishing the law that held that a temporarily seized person, as was this child, suffered any violation of his Fourth Amendment rights when the officer shot at the dog. Now, if you think about that, I mean, the violation of the rights was not detaining the family. Violation of the rights, in this case, was shooting the dog. But even under those circumstances, the court said that there had been no case where a detained person had been injured, even fatally, or even injured at all, by law enforcement, and therefore you couldn't say that the cop, the deputy in that case, had acted unreasonably. So it wasn't clearly established that the deputy under that circumstance couldn't do what he did. So he did it, and he was entitled to qualified immunity. It's a very powerful defense. All right, Doe versus Woodard, Fourth Circuit case out of Virginia. A warrantless strip search of a 4-year-old at a preschool by a state caseworker. There were abuse allegations that included this individual, this young 4-year-old. The caseworker was looking for bruises or marks on the child. It was clearly a violation of the child's Fourth Amendment rights. The caseworker was sued for violation of those rights, and the Fourth Circuit held that there had never been a case that said that a state caseworker couldn't do this. So even though there was a violation of the child's civil rights, the caseworker was entitled to qualified immunity. The case was dismissed. Now, the people who are attacking qualified immunity say, well, how could there ever be a case that says that you can't do this if you keep kicking these cases out on qualified immunity? Well, the answer to that is that sometimes there are prosecutions of the individual who, for example, would have allegedly abused this child, and under those circumstances there could have been a decision as to whether or not there was a violation of the child's civil rights, and then every police officer worth his salt and who attends classes like these would know that you can't do that kind of thing. Now, some of you may be scratching your heads and saying, well, even I know that you can't do that kind of thing, but we're not talking about you, we're talking about reasonable, these people who are out in the field who have done these stupid things, and we're trying to defend them. Baxter versus Brady. The case was, it's now on cert to the United States Supreme Court. Subject surrenders, he's got his hands up, and they release the dog on him to subdue him. The Sixth Circuit held that was protected by qualified immunity. So the action against the deputy for releasing the dog was protected by qualified immunity. The Supreme Court has granted writs to decide whether or not that was a violation of the civil rights and whether or not qualified immunity expands to that circumstance. The Sixth Circuit decided that there wasn't any case, they couldn't find a case that said that you couldn't release the dog under those circumstances. So you see, it's really very powerful, it's very broad, and it's a powerful defense that we use in almost every 1983 case that is filed. But here's the kicker. You have to be able to prove what your mental state was, what you were thinking at the time you did the thing that you're being sued for. So how do you prove that? You prove it, the best way to prove it is by contemporaneous evidence. The most contemporaneous evidence, of course, is a body camera, something like that, or an eyewitness. But what we're going to have more times than not is your report. So report writing is something that I stress in every class that we teach at the academy. Report writing is the evidence that we will use, the first place we will go to look to find evidence to defend you in these cases. We talked about a case, and it's for those of you who heard us do this at the academy, there was a case in Shreveport where in the Highland area, I think, this older woman came out to, she was dressed in a house robe and she had a little dog. There was an automobile accident, and so at the scene of the automobile accident, the responding officer was there, and he's trying to talk to the people who are hurt, and he's trying to talk to the people who are involved in the accident, and the lady in the robe is in his face saying, they're speeding up and down in the street all the time, and this is something that I've called you time and time again, and she had nothing to do with the accident, but she's standing there in his face, and he finally says, ma'am, you've got to let me do my job here. Well, she persists and doesn't do what he asks, and he ends up putting her on the ground. This is an elderly lady, older than I am, puts her and handcuffs her behind her back, and as in the process of putting her on the ground, the dog falls to the ground. Lady falls on top of the dog. Dog breaks all of her teeth in the front of the. And so anyway, it was a terrible situation. So the lady sues Shreveport police, and in the course of reviewing this case, we thought about what had actually happened. And there was at the time, there was no city ordinance or state law that said that what this lady had done in confronting the police officer was illegal. The police officer thought it was illegal, but it really wasn't. I mean, there was no ordinance that said you can't get in the officer's face. But he had written in his report that what she was really doing was interfering with the paramedics who had happened to be on the scene or were there responding to the police officer's call. There was an ordinance at the time that said interfering with paramedics was a misdemeanor. So even though what the officer thought he was doing was legal, and it wasn't legal. What he did was legal, but for the reason he didn't understand. He acted on a law that he wasn't thinking about at the time. But because he put those facts in his report, we were able to find that there was that violation. We put that forth as a defense under qualified immunity. It justified his actions because he thought that he was doing the right thing for the wrong reason. The moral of the story is that the more facts you put in, the better we are able to defend you with. So the facts are not just, I showed up, this is what happened, this is what I did, this is what they said. All those are important. But when you come to the part where you took the subject down, or you pulled your weapon and fired it, or you handcuffed the subject, or you made the decision as to whether or not to seek medical treatment, any of those decisions, when you make those decisions, be sure that you put down the reason, your thought process, what your state of mind was when you decide to make those decisions. So that's all important. Now, let's talk about qualified immunity a little bit more, and then we're going to talk about what to do in any lawsuit. How many of you have been sued as a result of your actions? Yeah, I see some hands that we know. So you get sued, and you're handed these papers, and you think, oh my gosh, what am I going to do with this now? Well, the first thing you do is what? Notify your supervisor, right? And those people are going to then start gathering the evidence, start pulling things together, and they're going to refer it all to us. So the next thing you do is what? You call up the other people who were involved in the incident, if you remember who they are, and you say, look, man, I've been sued. We ought to sit down and have coffee and make sure we get our story straight, right? No, that's a terrible idea. Terrible idea. You don't do that. The first thing you do is notify your supervisor, and then you sort of turn it over to them. You don't go around getting your story straight. You don't go around talking to everybody about this incident and trying to refresh your memory. You do pull out the report if that's what you want to do and refresh your memory about that. You don't talk to people that you don't know about it. How many of you have been in an automobile accident? You get a call from an adjuster and he says, I'd like to take a recorded statement from you. And you say, okay, I'll do that. You don't want to do that because you don't know who these people are and you don't know where that recorded statement is going to go. So you get this summons and you report it to your supervisor, and that's going to start the ball rolling, the process of the supervisor retaining counsel on your behalf, notifying the insurance company who will provide a defense for you. You all work for a great organization that maintains a great insurance policy at very high costs, right, to defend you all in circumstances like this. And so we have this process that we go through. We refer it to the insurance company. The insurance company sets up a file and starts directing the defense of this stuff. Your insurance company covers the defense of all the things that you would do out on the street, except for those things which would constitute either gross negligence or constitute actions which would give rise to punitive damages. I mean, you really have to go way off the reservation to give rise to punitive damages. Punitive damages are usually not covered by an insurance policy. They're almost always alleged. They ask for punitive damages because it's a nice, sexy thing to do, and it might be a big number. But punitive damages have to be, your actions have to be really egregious, like raping somebody in a squad car, that kind of egregious. So when you see those punitive damages, those are the kinds of things that you need to think about. It's a scary thing, but remember that you got to go way far off the reservation to get there. The scary thing about punitive damages is they're not covered by insurance. So if you ever get in a punitive damage situation, you're looking at your own policy, I mean your own pocketbook. So that's when you're getting to the point where the insurance company is not going to be paying off any kind of judgment or any kind of settlement based on punitive damages. But again, it's such a stretch that it's, I've never had a case where punitive damages were ever assessed, even though they're asked for in about every case. So the next thing that's going to happen is, once your heartbeat gets down to the right speed, you're going to get introduced to your lawyer. It's probably going to be me or my law partner, and we're going to sit you down and we're going to take you through the facts. We're going to gather the facts, and then we are going to start the process of defending the lawsuit. We're going to pull together all the evidence. That evidence is going to consist mainly of your recollection, and it's going to be based upon your report. A lot of these things, these people, talk to anybody who's been sued before, you're going to get sued over the things that you least expect. You're going to get sued over incidences that you may or may not ever remember. It's going to be a year before they get around to filing the lawsuit because that's how long they have to do it. It's going to be, if you're active and out there doing your job, there's going to be a lot of arrests and a lot of things between the time of that incident and the time a lawsuit hits. The fact is that you probably won't remember very much about it, but you are going to have your report, and that's what we're going to have to rely on. And you're going to have the reports of other people who were participants. And so remember that when you're writing these reports, it's important to write them as accurately as possible, fill them with as much detail. It's because you never know what's going to be important, like the old lady and the dog situation. The other thing that I want you to remember is that those of you who are supervisors, remember that 1983 includes supervisor liability. And that's kind of scary. Supervisor liability includes failure to supervise adequately, failure to take appropriate steps to correct behavior that you might see in those people that you supervise. If you have people out there who are doing some things that may give rise to some liability in the future, you need to be able to document that you took steps to do something about it. So supervisor liability is a real thing. The most common areas of claims under 1983 are excessive force claims and claims in the correction setting, which include claims for willful neglect of a correction inmate. Remember that up to the point that you subdue the individual, you're fighting with him. But from that point on, he's your responsibility. So in an instant, your whole role changes, and you've got to take care of him, and his well-being is what's important to you. So you got to make that adjustment and make it smoothly, and remember that that's the sort of thing that you have to be looking at. Remember that if there is any question in your mind as to whether or not medical treatment is warranted, you always want to go with erring on the side of extending the medical treatment and letting the medical professionals make a decision about whether or not the treatment is appropriate. I think we've been going almost 45 minutes. I want to talk a little bit about a case that Judge Drew pointed out to me not too long ago. Louisiana Supreme Court case, and we're going to play with this. I don't know if you all are familiar with this case, State v. Summers. It's a 2015 case, and I'm going to tell you a little bit about the facts. In State v. Summers, narcotics officers in New Orleans were on a stakeout, and they watched a car pull up, and there was a hand-to-hand exchange. And after that hand-to-hand exchange, the suspect started walking off along with some other passerby, and they, the officers who were observing or observed the hand-to-hand exchange called in the takedown team. Takedown team roll up, and as they're rolling up, they see the suspect walk into a yard, go to a porch. He's holding a bag in his hand, which appeared to have a beverage, and he comes back out of the yard without the bag and the beverage. So the undercover officer then, as the takedown team comes up to these individuals, they secure them. The undercover officer then tells one of the takedown team to go in there and retrieve the bag and the can, which they do, and it turns out that it contains crack, cocaine. So the question then becomes whether or not they violated his Fourth Amendment rights to unreasonable search and seizure by going into this enclosed yard and retrieving that bag. Now, the interesting part of it is that the Supreme Court had sort of addressed this issue in a case called Florida versus Jardines. The Supreme Court said that, answered the question, is it a violation of the Fourth Amendment for police to bring a drug-sniffing dog on people's property to obtain evidence of wrongdoing? What do you think is the answer to that question? The Supreme Court said it was yes. The Supreme Court said it is a violation of the Fourth Amendment rights. The unlawful search and seizure, it is unlawful, it is an unlawful search in violation of the Fourth Amendment for police to bring a drug-sniffing dog onto somebody's property to obtain evidence without probable cause. So that's what Jardine said. Now, in light of Jardine, what do you think the decision was in State versus Summers? Was the retrieval of the bag with the can a violation of the defendant's Fourth Amendment rights to an unreasonable search and seizure? The Supreme Court agreed with the fellow who's shaking his head. It was not, even though it sounds a whole lot like it. I mean, they saw this bag in his hand. There's the bag. He takes the bag and he hides it when he sees the cops running up. And the bag, in fact, contained the cocaine or the crack. So the question is whether or not that would have made him liable under a 1983 claim. You'd think that because it was clearly established that without probable cause you can't search somebody and you can't use a drug-sniffing dog, that you couldn't go into a private enclosure. And the Supreme Court, Louisiana Supreme Court said no. Said anybody could have walked up on that porch. They had enough under the totality of the circumstances, seeing the hand-to-hand handoff. They had enough to at least let them into the yard. And they said, and this was interesting, they said that the fella had put the bag and the can down and therefore discarded it. And therefore, it was reasonable for them to go and retrieve it as though it were in a trash can. So that was a case, that was a criminal prosecution. But it's important for us to focus on these criminal prosecution cases so that you'll know what is permissible, whether or not there is a violation of the Fourth Amendment, whether or not there is a constitutional violation. If there's no constitutional violation, there's no 1983 claim. If there is a constitutional violation, there would be a 1983 claim except for qualified immunity, which is judged under the totality of the circumstances and only fails when there's clearly established law. I think I've thoroughly confused or put all of you to sleep, or at least half of you, but I'm happy to answer any questions if you have any. All right, well, I guess yes, sir.
Do you have a strong feeling one way or the other about an officer writing his report while viewing the video? We've been sort of recommending it, but do you see anything wrong with that?
I don't. What I'd like to see, and I think it's more important that the officer write his report as closely temporally to the incident as possible. You're late. It's, you got a long break coming ahead of you. It's a late night arrest. and you say, I'll get to the paperwork when I come back. I've driven up to Plain Deal and I've deposited this guy. I just don't want to fill out the paperwork. Don't do that. The first thing the plaintiff's lawyer is going to do is he's going to say, well, this arrest occurred on the 17th and this report is on the 19th. I got a case right now where the date between the report and the incident was 2 days. And the guy's saying, well, did you use this time? Did you sleep during this time? Did you go out and get drunk? Did you have a big time? You know, the Saints played. Did you have, there's all sorts of things that he can impeach you with. Or did you use the time to get together with the other people who were involved and get your story straight? Those are the kind of things that the plaintiff's lawyer is going to do. Now, would you use your video? I think video is a great tool. I think that there are many circumstances, and you've seen them more than I have, the two of you have, that where the video doesn't show the whole picture. But if you're going to use the video, make sure that you look at everything, all the angles.
It seems like to me, if you have ready access to a video, I agree 100% with what Mr. Langley said, as close to the incident as possible, write that report. But if you have a ready means to make sure that the facts went like this, A, B, C, D, as opposed to A, D, C, whatever, it's better to get that straight because that can be devastating at trial. And to me, if a plaintiff's lawyer said, well, why did you look at the video if you remember what happened? The answer is, I feel like I'm an officer of the court. I'm trying to get it as perfect as I can. I checked what my recollection was, and I noticed that this was other than I remembered, and that can happen.
Yeah.
And the truth will get you by when nothing else will. The problem is some agencies don't have that video available instantly, and so they got to make a decision about whether to do the report now or get the video next week. I think you do the report now.
I agree. I think you do the report, and if you have to amend the report because of something else on the video, that's just the way it is. We'll handle that when we come to trial.
This is solid gold. Somebody think of a question, please. Anybody got a question? All right. Glenn Langley, sir, thank you for coming tonight. Let's everybody take about a 10-minute break. Let's give him a round of applause. That was solid gold. That's exactly what we wanted.
I am so blessed because I live with a man who is so vigilant that if I make any type of error at all, he's right there to correct me and point out the error of my ways. It's just wonderful.
That's nice, sugar. Okay. It's a full-time job. Over here we got a young man just starting out in life. His name is Jeff Cox. Now some people can't get out of Minden. Gene and I couldn't get out of Minden. Jeff got out of Minden, but his heart's still over there. Jeff's on the Second Circuit where Gene and I used to work. We're going to try to cover some stuff in 2 hours worth in 1 hour, so let's get it together. We bring gifts. As long as Gene and I are percolating, here's what's going to be available for you 1 minute after midnight on August 1st. That's when the statutes change. That's the general date that the statutes are going to change. There may be 3% of them become effective on a different date because it's written in the bill like that. But right after midnight on August 1st, some of y'all remember it used to be August 15th, the laws are going to change. And this is going to, what we have available for you is Title 14. It's a low enough quality of life in July as it is for me and Gene typing this stuff in plink, plink, plink. But you will have every statute in Title 14 on our little website. And it's going to, everything that's new is going to have a yellow background. We used to shade the stuff in the book. Now we're going all electric. Here's what you do. On August the 1st, you go www.drewlawbooks.com. Then there's a rectangle down there that says, you want some Title 14? Click here. Boom. Then you hit Control F like it's asking a question. This box comes down. What words are you looking for? Type them in, hit Enter. There it is. There it is. And you will have the current law when nobody else in the state will have it. Sort of important to have the current law, particularly if you're making an arrest. It's good to know what the law is when you're making an arrest. You live in a state where Article 220 says they can resist you if you make an unlawful arrest. So it's this simple, and if I can do it, anybody can do it. You go to drewlawbooks.com, pop, doesn't cost anything. little rectangle has Title 14 in it, click. You hit Control F, and then the box comes down, and you type in a few words and go enter. It'll take you to that statute right there. And it's important, particularly the legislature does the same thing. The legislative website is excellent. And all three of us use it all the time, but they've got to do all 56 titles and half a dozen codes and the Constitution, all this stuff. We do Title 14, but like on the Title 14 through the legislative website, it wasn't up till September 25th, 55 days after the laws changed. And so they're doing all that they can do. But if you want Title 14, we got you some Title 14. What we put in the book is different this year. We saw we were putting more and more and more stuff in Title 14 that you'll never use. You'll never touch it. So that's why we printed in the book only the stuff we, subjectively, we think you might have a possibility of using. Chapter 2, you're going to have homicides, you're going to have robberies, kidnapping, rape, burglaries, disturbing the peace, resisting an officer, flight from an officer. You're going to have the stuff you're going to use day to day to day. Chapter 3, we got something different. Everything on domestic violence, the reason it's so hard is it's spread out all over the law. It's everywhere. And so we pulled every statute we could think of, primarily related to domestic violence, and including a lot of Title 14, and we put it in Chapter 3. So if you got a DV case, go to Chapter 3, and you might find something that'll help you in there. Then probably the most important chapter, Chapter 4, about search and seizure. Chapter 5 has got the 5th and 6th Amendment in it. But we think it'll be helpful to you, and most of the comments are in boldface. Some of the new stuff in the book will underline, but it's not nearly as effective as you go look at it on the website because it's marked in yellow. Brand new legislation here. This statute's been on the books a dozen years. It's been totally unused, totally unusable. Because what the statute said for some reason was if anybody tries to disarm you before the crime occurs, it's got to be a piece of equipment that was issued to you by the department. And let me tell you what, about 30 miles east of here over in the woods of Webster Parish, they all got to buy their own service revolver. They want to have X, Y, or Z. More than likely over there in Webster, they're buying their own stuff. So this statute didn't apply if it's some of the officer bought their own stuff. Here's what the deal is now. If they have, there's 10 pieces of equipment. If they have one of those pieces of equipment that they're wearing, and somebody tries to grab it, as long as the sheriff or the chief has a written policy allowing them to carry that, then it's going to be good to go. Finally, this 34.6 will have some teeth in it. There's what the statute would allow. Any of those 10 items right there. Now, some sheriffs and some chiefs may not want you to carry all of that. Some chiefs don't want their officers carrying the taser, the one on the bottom right. But it's like whatever the sheriff wants, said all deputies in the Bossier Parish SO shall be authorized to carry, and then list from 1 to 10 of them. They'll probably list all 10 of them and utilize them in conformity with the certification and use only the minimum force necessary to achieve a lawful objective. Julian Whittington Sheriff. That's all it takes. And then 34.6 will help. Flight from an officer. This is a crime that's right after resisting an officer. Good news on this front here. The two statutes for many, many, many years that needed to be felonies that were misdemeanors were aggravated assault, back when ag assault would include pointing a firearm at somebody. Now pointing a firearm at somebody to scare them, that's a 10-year felony, 37.4. But ag assault with a crowbar, putting somebody in fear of getting hit with a stick, that's still a misdemeanor. This flight from an officer here, the only target defendant is the driver of a motor vehicle. That's the only target defendant. It's 108.1 right after resisting. And here's what it has to be. It has to be someone who refuses to stop when being pursued by a marked unit using lights and signs. That's the misdemeanor version of it. And then the legislature saw we got more and more and more people getting hurt with these high-speed pursuits. Nothing like the number and frequency of high-speed pursuits today as compared with 35 years ago. It's unbelievable how many fewer there are. So the legislature said, we're going to come up with 4 ways. If you prove 2 of them, you've got a felony. Then they said, now we got 6 ways. And if you prove there's 2 ways to make this statute work. Here are the 6 things you got to show. And The factor is, do you have human life in danger? And here's how it works. Did the driver who won't stop, did he force somebody off the roadway, or did he leave the roadway himself? Did you run a stop sign, singular, or a red, or a yield sign, singular? Then number 3, was he going 25 more over the speed limit? Did he run a red light? Did he travel against traffic? Did he have a collision? Those are the 6 factors. It can be proven one of 2 ways. One is what everybody was teaching for years, was you prove any 2 of these 6, now you got your 5-year felony of aggravated flight from an officer under the C and D part of 108.1. Look what the legislature came up with this in May. There's another way, and it was right there in front of our eyes, and I never had seen it. They said if you prove any one of these factors occurred twice, you got the felony. In other words, if he runs a stop sign now, then he runs a stop sign 3 miles later, that makes too much sense. That makes absolute sense. And look how you can back it up. Look at items 1, 2, 4, and 6 there. There's no other way to look at those items other than their singular acts. Singular acts. It could have said, like number 1, or runs other vehicles, plural, off the roadway. Or number 2, it could have said, run stop signs, plural, or yield signs, plural. It didn't. It's all singular. So the Louisiana Supreme Court, maybe there's a reason they're on the Supreme Court. They figured it out, and they said there's 2 ways to prove it. You prove any 2 of them, you're good to go on the felony. You prove that he committed one of them twice, you're good to go on the felony. This is something that Judge Cox and Ms. Jean and I, occasionally, we do a little good. Here's something. Serious bodily injury, it's statutorily defined. It's not like great and immediate bodily harm. It's not like injury requires medical attention. It's got to be defined by statute. Unfortunately, until August the 1st of this year, there are 21 examples of crimes that got enhanced because of the state being able to prove serious bodily injury. 6 of the versions, you had one of 5 elements you could establish serious bodily injury by proving. 5 crimes, you had any one of 4 you could prove to make it into serious bodily injury, and one time you had 3 ways. It's a mess. 9 statutes didn't define it. So Representative McMahon, the 3 of us put our heads together. We said, is there a legislator in North Louisiana who doesn't have us all on call block, who would avoid us? And we finally found Representative McMahon in Spring Hill. He did a great job. This passed Act 2. He did a great job getting it through the legislature. So every time you read that phrase in Title 14, serious bodily injury, it'll be defined the same 5 ways. Any of the 5 ways. Extreme pain, obvious and protracted disfigurement, impairment or loss of an organ or mental faculty, unconscious or near-death experience. All 21 types. In addition, the Department of Health and Human Resources, the crisis intervention ladies already had one on the books additional for abuse of children, and that's in 403, and it's malnutrition or starvation. That's just involving the bad things done to little children. But anytime in Title 14, you go back, look at the bottom of page 15, please. On the bottom of page 15, you will see section 2, subsection C. 2 is where you see all the definitions, basic definitions of Title 14. You look at the bottom of the page that's underlined down there, that's subsection C. That's the only time you're going to see serious bodily injury defined in Title 14, because the legislature removed all the individual definitions from the other 21 statutes. The reason for that is human nature, because if there was 21 definitions here, there, and yonder, maybe a legislature might amend one, but not amend the other ones, and that's how this mess has come about. So there's one place to go for the definition of serious bodily injury: extreme pain, disfigurement, impairment or loss of an organ, impairment, unconscious, and near-death experience. On these serious bodily injuries here, we tried to do it for Title 32, but it got scraped off. But we did do some good, I think, in Title 32. We'll tell you about that in a minute. Jean's going to talk to you real quickly about implied consent.
We've talked about this before, but it's important, and we're just going to touch on it. You know that implied consent, every state in the union has implied consent laws.
Okay, I'll take it.
A driver agrees before ever leaving home that if an officer has probable cause to think they're driving while impaired, that officer can require that person to submit to a chemical test. And under implied consent, the driver has agreed before getting on the road that he or she will take that test. Over time, the refusal rates kept going up and up. So some states in the Union made it a crime with penalties just as severe as the penalty for DWI itself to refuse to take the test. In the Supreme Court case in 2016 in Birchville, the court looked at 3 different DWI cases where drivers had refused to take the test. The court concluded, the bottom line is that it is unreasonable for a person to agree before they leave the house that they are going to submit to a blood draw. In that case, the court said this was an extreme invasion of privacy that involved piercing the body. It was painful, and a huge factor was the fact that once that blood is taken, after the blood alcohol is analyzed, the state would be left with a sample that conceivably they could get all sorts of additional information about the person whose blood were taken. So the court said, under DWI arrest, a person cannot be subjected to a warrantless blood draw. If a person actually consents, that's great. But if the person doesn't consent to have blood tests done, you need to get a warrant as quickly as possible. And on the other hand, in breath tests, the court said requiring a person to submit to a breath test without a warrant is lawful. You do not have to have a search warrant to mandate that a person take a breath test. But there's a little tricky part there, Harmon.
Well, we've talked about it before. Unless you can really talk to the person one-on-one, some people have people skills, some people don't. I don't think you have a physical way to make him physically take that breath test. I'm talking about physically. Legally, he has to. Suggestion, sir, I've developed probable cause that you're impaired. You're arrested for DWI. You've got to take a breath test. That's what the legislature says. That's what the U.S. Supreme Court says. You have to take a breath test. If you'd rather take a blood test, we'll make arrangements for that also. Some people would prefer a blood test. They think it's more accurate. That's on you. But you're going to have to at least take a breath test. That's all lawful. That's all correct. They have to legally take a breath test. I'm just saying physically, if they've been to the third DWI, the lawyers told them by then they just don't do anything and don't blow in the machine. We have a little thing that we came out with this year it's a Bossier case, and it's a sad situation that happened on Benton Road, and it's just the worst case scenario. And basically what happened was there was a wreck. Somebody ran a stop sign in a truck, I think, and killed a little 4-year-old. And 3 of us came into contact with Miss Grantham, and she could not believe that there wasn't a mandatory test for this person. Well, 2 great DRE and horizontal gaze and nystagmus guys from Troop G, 2 of the best, couldn't find anything on the guys. Couldn't find no indicia of impairment. All they got was running a stop sign, and a week or so later, the little 4-year-old died. Her name was Katie Buck. And so this mother said, this cannot be. She got so tired of people saying, but your daughter wasn't dead yet. But that's what the law was. Look here. Everything in implied consent, technically what that is a statutory version of search, incident, arrest. I didn't figure that out until 10 or 12 years ago. But we're normally on an arrest, you talk about search, incident, and arrest. That's what implied consent is, because it's the intersection of scientific, medical, legal things, and this SITA, all of the statutes in implied consent, except the last one, talk about impairment. Start with 661 all the way up to, but not including 681. 681 is the last implied consent statute. And basically what it said at the time was, if there's a fatality, somebody was driving on the public highway, every driver's going to have to take a test. That's what it said right there. And if there was impairment, they got all these other statutes that they could have used that night, but there was no indicia of impairment. There was a lot going on. There's a ton of traffic, a lot of plates spinning. Bottom line, worst case scenario, they didn't get to the inventory done for 2 days. There's methamphetamines and some other stuff in the truck. And this guy worked for a company that said if you're in a accident, you've got to give a test immediately. He quit his job that night rather than take a test. So there's no question that something was going on. And you know, it's sort of heartbreaking because there's one of the types of vehicular homicide that all you got to show there's any detectable amount of schedules 1 through 4. So there's no telling what this guy could have been looking at, but it's just one of these things that happened. But for whatever reasons, these 2 officers didn't pick up any impairments, so all they got was a ticket. So this is Miss Grantham. I hope y'all get to meet her. She like moved a 1,000-pound marshmallow up a hill. It's amazing what she did.
We have so much respect for this lady because she took just a completely horrible situation and worked unbelievably hard. And there were so many times I feel like I would have given up and said, oh, this just isn't going to happen. She never wavered, and eventually it got through the legislature so that now this 681, not only in a fatality, but in a situation where there is suspected serious injury, and Harmon will talk to you about those particular things in a minute, the problem is still the same. 681, without any indication of impairment in the statute, mandates police officers to get a chemical test if there's a fatality or if there's one of these suspected serious injuries. We're still saying if you need to get a blood test, get that warrant if the person won't consent. That problem is still there, Harmon.
Well, there's a big difference in having to get a search warrant in the 60s and having to get the search warrant today. If you get a search warrant in 30 or 45 minutes, man, that's a ticket. Some people say, we don't have time to get a search warrant. The Pac-Man's eating away at the BAC every minute. Well, you got to observe the guy 20 minutes on a breath test. It's like a search warrant is the only thing that's going to shift the burden to motion suppress. Look at the 7 types of injuries. And these things didn't just get invented out of the air. That's what is now going to be on the national crash reports. Not the numerical ratings about the injuries, the 1 and the 2 and whatever. It's this stuff. Brand new. Your crash forms are all going to change this year. And those are the items: severe lacerations, crushing injuries, broken or distorted extremities, significant burns, unconsciousness when taken from the same paralysis, or serious injury to skull, chest, or abdomen. These are the facts you'll be looking for. And so even without impairment, if there's an operation on the public highway and there's a fatality or one of these 7 items, they have to take a chemical test. But the only one lawfully they can be made to take legally is a breath test. But physically, it's going to take somebody with some persuasion to get them to submit to the test. And Judge Cox is going to tell you about tell them about that F part, if you will, and also the Wisconsin case. Please.
Okay. The good thing about Katie Bugg's law, one good thing that came out of Katie Bugg's law is for law enforcement officers, because subsection F, and Judge Drew and Ms. Drew were very responsible for this. Law enforcement officers were kindly put into a trick bag. Basically, victims' families were suing law enforcement officers because they were not getting the chemical test if there was a fatality or serious bodily injury at the accident scene. The other side of it was states were suing, defendants were suing the law enforcement officers because they were taking the chemical test. So subsection F says that if you follow Katie's Bug law and you take a chemical test, basically you cannot be sued. You have immunity from any kind of suit for getting that chemical test. So subsection F was added to Katie's Bug law and protects you as law enforcement officers for getting those tests. Again, though, remember, Birchfield is out there and you have to get a search warrant before you're going to be able to get a blood test. However, Mitchell versus Wisconsin just came out a few weeks ago in 2019. This is an interesting case because Mr. Mitchell was having a long winter's night. He had been drinking at the local bar, and Mr. Mitchell was going to leave the bar, and patrons at the bar called the local law enforcement officers and said, Mr. Mitchell's leaving, and he's intoxicated. They went out to a local lake, and they found Mr. Mitchell wandering around the lake. And when Mr. Mitchell got up to him, they gave him a field breath test. Mr. Mitchell had a little blood in his alcohol. He was 0.24% at that point in time. So they put him in the back of the car, and they're going to take him down to the police station to have an official breath test taken. Well, Mr. Mitchell did the next best thing. He passed out in the back of the police car. So the police officer just wheeled into the local hospital, put Mr. Mitchell into a wheelchair, rolled him into the emergency room, and stood in front of Mr. Mitchell and said, Mr. Mitchell, you have the right to remain silent. You have the right to an attorney. You have the right not to take a chemical test. You have the right to not take a breath test. You have the right not to take a blood draw. And Mr. Mitchell was doing so. At that point in time, the officer looked at the nurse and says, nurse, draw the blood test. The nurse drew the blood test, and sure enough, Mr. Mitchell still had blood in his alcohol. He was at 0.22% at that point in time. It went to the United States Supreme Court. The Supreme Court was faced with a warrantless blood draw on an unconscious victim. Now, the difference between Birchfield and Mr. Mitchell was in Birchfield, Mr. Birchfield was conscious and able to assert his rights. In Mr. Mitchell's case, he was unconscious. The Supreme Court said under exigent circumstances and under these particular facts that they will almost always allow a blood draw in this situation. They also said generally this is allowable. Now, judges love almost always and generally. That means that under the facts of these circumstances, based on an unconscious victim, that you can almost always count on this case to be able to get a blood draw from an unconscious person, generally, okay?
I mean, the thing is, that's known as CYA, I think it is, but it's like, I think it'd be good to have a policy about that in your agency about whether you're going to proceed or not. But the good news is, there is a certain portion of impaired operators, if they're actually comatose, it looks like the blood draws will be okay on that. If they're comatose, if they're unconscious, they're not going to be able to do a breath test anyway. But it looks like if you got to go through the whole list, see if they make any objection to the deal, and then if they don't make an objection, it looks like you're going to be okay on that. As soon as we say that, there's some judge hadn't had his breakfast that morning, may rule the other way. But this is a grown-up job you have here. We've got some domestic violence we need Judge Cox to hit on real quickly, please.
All right. When we're talking about domestic violence is the worst kind of case that you'll ever walk out on. I mean, basically, we understand that and we know that. When you get out of your vehicle, I know that most of y'all have cameras. Is that correct, that y'all are using them? Make sure that you get those cameras started before you get out of the vehicle, because people may say something. A lady may be coming to you saying, he's trying to kill me, he's trying to kill me. Basically, you need to get that on video, because the next morning, usually what's happening, they're at the prosecutor, they're at your office, trying to get the charges dismissed. If you're going to talk to the parties, you need to separate the parties. That's very important that you separate the parties to be able to talk to the parties. And basically, you have to determine who the predominant aggressor is. Now, Tammy Jump, which teaches with us, is an ADA out of Bienville Parish. She does a lot of these domestic violence situations. She says sometimes it's very hard to determine who the predominant aggressor is. But you have to make a determination. And you have to make that determination as to who is the predominant aggressor. And then you have to determine what their living status is, because we know, if I could borrow the clicker, please. We know that basically you have to determine their living status, because battery of a dating partner or domestic abuse battery are the two statutes talking about aggravated assault of a dating partner or domestic abuse aggravated assault. Depends on that. If they have lived together at any time in the past, it used to be 5 years, it's no longer 5 years. Any time in the past, if they have lived together as husband and wife, father, child, anytime in the past, you can arrest them for domestic abuse battery. Domestic abuse battery carries a little bit stiffer penalties typically and has harsher penalties based on that, on second convictions and things of that nature. Plus, you may be able to take their guns away for those convictions. Dating partners. How do you define dating partners? Well, Tammy Jump taught us a new word. Have y'all ever heard of the word, we're just talking? She says that.
Tell the truth.
Tell the truth. How many of y'all heard we just talking? Basically, that means that it's not just a dating relationship, that they are actually having, don't show anything, showing they are having sexual relations together, and it's more than one time. You have to have a continual relationship. But you have to know what's going on, and you have to document that in your files. You need to document what the relationship is, because that's very, very important. Now, Chapter 3 has all of these things listed. For example, stalking. That's usually more than a couple of times in a situation. You have cyber stalking. You have home invasion, where the person actually kicks the door in, and that carries some very, very serious time. You have violation of protection order. The firearm, if they have possession of a firearm and they've been convicted before of domestic abuse battery, or telephone harassment, but all of those are in Chapter 3. If they have been arrested for domestic abuse battery, you have the firearm divestiture program, which the judges can come in now and make them give away their guns while they're under these charges. They can go to a third person, but you have to make sure that that third person is not going to give these guns back during hunting season or let them have access to them. Or the judge can order the sheriff to remove the arms and keep the arms away from the person. It's very important that you understand the protective orders. Protective orders are given by the clerk of court. Basically what happens is the protective order is filed for by the victim. They go to the judge's office, the judge signs off on it, goes back to the clerk of court's office, and then it's served upon the person that is the violator, the person that has been harassing the person seeking the protective order. Typically what happens though, 4:30 on Friday afternoon, what happens? Person comes in and they get a protective order, right? Judge sits there till 6:30 or 7 o'clock waiting for them to fill it out, signs it, goes back down to the clerk's office, they give a copy of the protective order, and at 10 o'clock the guy shows back up at the house and hasn't been served with a protective order, right? So then what can you do? You go out to the house, the lady says, here's my protective order. You can take that protective order and you can serve it on that person at that time, but you have to note that in your police report. If you note that, you have to note that in the police report, because if you don't note it in the police report, there was never any service. Number one. Number two is, you can ask the person, sir, you have now been served with this protective order, you have to leave. As Judge Drew likes to say, 1 hippopotamus, 2 hippopotamus, 3 hippopotamus, and if he doesn't leave by 5 hippopotamus, guess what you get to do? You get to tell him, now you're under arrest for violation of a protective order. Guess what happens at that point? Search incident to arrest, okay? So basically, he has to leave at that point. If you are called on a domestic violence situation, whether you arrest the person or not, you have to write a report. If you don't write a report, what is going to happen is that you lose your qualified immunity. You have to write a report on every domestic violence call that you go out on. Also in the book, there is a chapter on 195, page 195, 196, I believe, that says what your duties are. Your duties are to protect the victim in these situations. Your ultimate duty is to protect the victim. If you do not protect the victim in these situations, you can be sued for that. One thing that I want you to remember is that all of these statutes apply to same-sex couples now, number one. Number two is, the other thing is, can a lady violate can she overdo her own protective order? For example, she calls the guy and says, hey honey, we need to discuss about the kids. Why don't you come over to my house? Why don't you come over here? Okay? How many of y'all have had situations like that where the woman has invited the man back over? She absolutely cannot overturn the protective order. The only people that can overturn the protective order is the judge's office. She can invite him over. If he goes over, he is in violation of the protective order. If he is there and they've been living together for 6 months, these things can last up to 18 months once it's granted by the court, and she ain't gone back and dismissed the protective order, and she calls you and says, he's over here, and I have a protective order, he's in violation of protective order. He has to be arrested at that point in time because of violation of a protective order. I know it's not fair, but the other side of it is only a judge can overturn the protective order. Make sure that you get copies of their phone numbers of the victims. Make sure that it is a landline. Get grandma's number, get anybody else's number that has a landline, because Tammy likes to say her victims in Bienville Parish change numbers like drug dealers, especially cell phones. So make sure you get a landline to be able to contact them. Note in your report, make sure that you give them a latest report, and make sure that you have all witnesses' names. Make sure you document everything that was said, because the next morning they're always back in saying that the guy, they need to forgive him or whatever, potentially, and the prosecutor may need that information for the future. Okay?
Thank you, Judge. Look real quickly on page 195, please. Under the B part, it's right there in the middle of the page. It's 1 through 4. Where my fingers are there, you need to mark that. That, in a nutshell, is what you're supposed to do. Now, you may remember there used to be a very similar statute in the Children's Code that started out almost exactly the same. Just like we were talking earlier about if you had serious bodily injury in 21 different statutes, some would get amended and some wouldn't. Well, the one in the Children's Code hadn't been touched since like 1981. This Title 46 gets adjusted about every couple of years. So if you look on page 195 under B, 1 through 4, right in the middle of the page, that's the basic stuff you're supposed to do. If nothing else, if you make service with her paperwork, and most of the clerks are going to give her 1 or 2 copies of the certified paperwork, you have to make a note in your report, not to the extent like a civil service deal, receive the papers and effectuated certain kind of service on this. It's not like a whole big, long report. It's just like saying, I got the victim's paperwork, and with her agreement, I served them with the documents there at the scene. It doesn't have to be a lot of detail to it, but it's got to be put in there. And like Judge Cox said, if you work a DV case, your qualified immunity flies out the window if you don't make a report. That's whether you make an arrest or not. You've got to make an arrest in every DV kind of report. Gene's going to tell you about Carpenter versus U.S. We got 25 minutes, now y'all stay with us. We'll do some good.
Okay, this is a really interesting case. It's a U.S. Supreme Court case. It's on page 150 in your book, and it deals with cell site location information. The opinion started off with the court pointing out how many more tens of millions there are cell phones in this country than there are actual men, women, and children.
I found that's my printing up here about page 140. I found that today, and I should have told you about it. There's a slightly better explanation of Carpenter on page 140. It's not a whole lot different, but I neglected to tell you that. Just a little trick of the trade, honey.
Always helpful, pointing out any possible mistake. Okay, go to 140, it is there. Okay,
But I like 152.
okay. Cell site location information means that when you're out with your cell phone, several times a minute, it is pinging off of the nearest tower. And this information is stored by the cell phone provider. They use it for their own business purposes, and it's more and more being used as a tool by law enforcement to see where people are at particular times. In this case, this happened in Detroit, and there were a bunch of robberies of some different electronic stores. In 2011, Officers arrested 4 people involved, and one of them ID'd 15 other accomplices and gave some of their cell phone numbers. The FBI used the Stored Communications Act, a federal law, which allows law officers to acquire past cell site location information when the law enforcement agency has specific facts to show that there are reasonable grounds to believe that those records are relevant to an ongoing criminal investigation. Carpenter turned out to be the lead dog in all this robberies, and over a period of about 4 months, the FBI got 13,000 cell site location pings on him, which averaged about 100 a day. And it turned out that his phone was at the exact location and time of 4 of these robberies. We all know that the U.S. Constitution, 4th Amendment, protects people from government's unreasonable searches and seizures. In this case, dealt with the issue of how we apply the 4th Amendment to today's easy ability to chronicle a person's past movements through those cell phone signals. You know yourself that technology each month is improving, and as more and more towers become available, they can pinpoint all of our movements much more precisely. What the court said was that a person does not surrender their right to privacy just by going out into public. Each of us has a reasonable expectation of privacy concerning our physical movements. This cell site location information provides an intimate window into the utmost privacy of people's past life. The court observed that a cell phone is almost like a feature of human anatomy, and that people have to have a cell phone because they are pervasive and a necessary part of daily life in order to participate in society. Probably everyone in this room has at least one cell phone and maybe more. The court here held it's a very narrow holding and a limited holding. The court stressed that. The court said we're only going to decide what is in front of us, and what the decision was to get 7 days of cell site location information is a 4th Amendment search, and you have to get that making a probable cause showing and getting a search warrant. They didn't tell us if you could do it for 1 day without a search warrant, 2, 5. They didn't answer that question. They also said that the court decision about cell site location information about past movements doesn't have any effect on real-time tower dumps, on conventional surveillance like security cameras, on foreign affairs, national security, and in true emergencies like fleeing felons, people in imminent danger of immediate harm, imminent destruction of evidence, active shooters, bomb threats, child abductions. This holding doesn't apply to any of that. But the bottom line is to get cell site location information about a person's past movements, you have to use a search warrant based on a showing of probable cause. And if you need cell site location information, the wise course of action is to get it with a warrant. Harmon?
Okay, the last murder case I wrote at the Second Circuit, the bad guy lived right up here. And when the 2 ladies got killed that night down here, he said, I never left my house. I was there all night. Yet his cell phone, about 2:30 in the morning, went beep, 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 got to the slaughterhouse, 32, 33 minutes, and then beep, 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 back to his house. You talk about strong evidence when he says he never left his house. Well, his cell phone did, and he went to the scene of the murders and then went back. Just like in this case in Carpenter, they relied very strongly on the fact that on at least 4 of these robberies, Carpenter was right there. And I don't know what the coincidences are in life, but this is important. Unfortunately, The statute this is based on, the Stored Communications Act, still reads the same way. And it still says all you gotta do to get cell site location information is to make a showing that information relevant to an ongoing investigation might be gotten. That's not probable cause. It's nowhere near probable cause. I wouldn't take a chance on, well, they said 7 days is too much. Maybe 4 days would be okay. I wouldn't take a chance on that. You can get a search warrant now in less than an hour. Let's do that. That's the way to do it. And on a search warrant, what your DA is going to do if you secure evidence relative to a search warrant, even if there is a motion to suppress file, the most that the prosecutor's going to have to do at the motion to suppress is say, may it please the court, we call a case of State versus Adam Jones. If the police court would make a showing here to file the affidavit support of the search warrant in return, and upon them being received in evidence, we tender to the defendant. Because you got a search warrant, in effect, that shifts the burden. But yet, a good officer who looks up the Stored Communication Act will see it's still saying the same thing. Nothing to it. All you got to show that it might reveal some evidence relevant to an ongoing investigation. That's scary. Just like sending the letter to the Prescription Monitoring Board in Louisiana, still in Title 40, it's right there. You send the letter, 3 days later you get the pharmaceutical and medical history. Guess what? You need a search warrant for that, but yet it's still on the books. And we got some little bad news here, folks, real quickly. Again, if you have access to the video, I agree with Mr. Langley. Speed is important, but if you can have access to your video, that's a golden opportunity to make sure that you've got it right. Once it goes in the system, you can file a supplemental report, but you're not getting that report back. So if you got access to the video, I think you look at it as far as victim and witness information. Jean's best friend is a mean lady in Webster, and she's always fussing about hard to get a hold of victims and witnesses. You know who I'm talking about. And but she makes good banana pudding. But anyway, you can't subpoena a post office box, and cell phones are going to change. So the more landlines and hard addresses you can get, the better. Same with Lavins. And as Mr. Langley said, an extensive, detailed, and accurate report is not only your best friend, it's the best friend of the prosecutor. Because anything you find out that you know is imputable to the DA. And you can get some prosecutors suspended from the practice of the law, like one was done in New Orleans a few years ago for really not piecing together what 3 different folders said by 3 different law enforcement officers. And it's like, it's scary. So the more detailed, the better. For one thing, it helps your credibility when you put it down. It'll help the DA to screen the case. It'll help the DA make sure they're not violating Brady versus Maryland back in the 60s. Before, I think, 63, the DAs could hide the weenie. They can't do that anymore. If it's favorable evidence, they got to make it known to the DA. If you're running a lineup and the little old lady picks out the wrong guy, you don't go tell that to the defense lawyer, but you sure put it in a report to the DA because he's going to have to do something with it. But you've got to make that known that the victim picked out the wrong person. This is a problem, and this isn't good, and this is amazing, and we'll get y'all all depressed before you go home. In the 70s, 80s, and early 90s, search and seizure was subjective. What was this officer thinking? What was going on in this officer's mind? And I'm talking about straight criminal search and seizure now. But then, and like, I give you an example, there was no such thing as a good pretextual traffic stop. In other words, if the law enforcement officer said, you know, I've heard some bad stuff about this guy, but nothing that's actionable. But guess what? He just passed me and, yeah, crossed the fog line twice. That's a 32:79, I got me a traffic ticket. That'll buy me 10 or 12 minutes to talk to him. Maybe I'll get some information. Before 1996, you couldn't do it. Now the only question about a traffic stop is, did you observe the infraction? If you saw the infraction, that's a good stop. The problem is extending the stop. You can't extend that stop for a minute, literally not a minute after the reason for the stop is over with, unless you discover additional reasons of suspicious criminal activity that occurred during the stop. So it's like easy to make stops today, but it's harder to extend the stops. Now, you start, the name of the case was a Wren case, W-H-R-E-N, Wren versus U.S. And what it says was, we're going to an objective standard. We're going to figure out what the facts are. Once we know what the facts are, it may be that law enforcement officer had one exception to the warrant requirement that he or she was thinking about. Maybe the district judge comes up with another one, or the prosecutor, or maybe the appeals court. The important thing was getting the facts right. And then somebody down the line could come up with an exception to the warrant requirement that maybe the officer in the street wasn't thinking about. It happens all the time. We've had a couple of good cases, State versus Kelly, K-E-L-L-E-Y, out of Louisiana Supreme Court, and State versus Surtain, S-U-R-T-A-I-N. They're both in the book in chapter 4. If you ever got 20, 30 minutes of time, you go Google Louisiana Supreme Court, State versus Surtain, S-U-R-T-A-I-N, or State versus Kelly. Real quickly, State versus Kelly, the officer was getting the person out of the car because the officer thought he had PC for driving under suspension and seized a bunch of drugs. The argument below was maybe there wasn't PC. It's a close question. The vehicle wasn't running. Key was in the ignition. No testimony about the hood being hot. But what the Louisiana Supreme Court said was, if somebody has somebody lawfully detained in a motor vehicle, you always have the right to get them out of the car if you want to see the hands of officer safety. Or you got the right to keep them in the car. That person belongs to you, whatever you're comfortable with. Some of the ages we teach have gone back to having them keep their hands on the top of the steering wheel. But whatever it is, that's on you, how you want them to behave right there. So the question was, what did the officer do when he got him out of the car? Was there a legal justification to get him out of the car? Yes, officer safety. But he really got him out because he wanted to arrest him for DUS. That doesn't matter. Objectively, what did he do? Got him out. Is there a legal justification? Yes, officer safety. Now, that straight ahead, Wren versus U.S. objective, let's determine the facts and see what comes from that. Little change in 2013 that Gene and I thought was just sort of somebody not looking at the law clerk closely enough, and we thought it had to be a mistake. And unfortunately, it's been repeated now in this Collins case, 2018. And know this, anytime you make a search or a seizure and there's not a warrant, the presumption is it's invalid. It can be, you can satisfy the presumption, but if you don't have a search warrant, and back in the day, I used to tell officers, you can't get a search warrant every time you want to scratch because you can't spend 4 or 5 hours at a time covering yourself on everything that comes up. But now you can get a search warrant in 30 minutes. Yeah, that's a good trade-off. But anyway, here's Collins versus Virginia. Look here. This is somebody's yard on this table. Here is the house. That house has a great deal of protection. The only thing that has more Social Security protection than this house is somebody's person, and really it's the inside of somebody's person. The house is the next. And for all these years, we've been teaching, and everybody I know that's been teaching this way. Right around the house is the curtilage. It's the area where personal life occurs. It's where Mama's got her garden, Daddy's got his barbecue pit, Junior's got his basketball goal. It's the area right around the house. That has a great deal of protection. Not as much as the house, but a great deal of protection. Guess what? We now got 2 cases. The Jardine's case, where they took the drug dog to the door, gave the dog the instruction. The dog sniffed the air under the front door, alerted. The 2 officers and the canine left, and that was the sole information that was utilized for the search warrant, for the affidavit support for search warrant. And the U.S. Supreme Court said you can't do that. They said that was a trespass. They said in that case in 2013, you couldn't, if some item is in the curtilage, like on the front porch, the front yard, it can't be protected any more than if it was in the living room. It's just as protected. Come up here to Collins versus Virginia. This is stunning. This guy has an orange and black extended motorcycle, eluded the police twice in the weeks previous to the search that occurred here, at speeds of in excess of 145 miles an hour. The guy goes on Facebook at his girlfriend's house and showing off his orange and black extended motorcycle. One of the law officers has to troll through there and sees it. Says, I know where that house is. Yeah, that's his girlfriend. I know exactly where that is. So the person goes to the home, and right up there where the photo had been taken, they couldn't see an orange and black extended motorcycle. They saw what looked to be that with a tarp over it. I don't think a tarp was a huge factor, but it made it a little more difficult. So what did this officer do? This officer did exactly what I would have told him to do. Walk up in the front yard, just like every Brownie Scout can do, just like the welcome wagon lady, just like the FedEx postman, somebody, a door-to-door salesman. Go up there, look, see if you can identify this vehicle. So he goes up there and pulls up the tarp, click on the license plate, click on the serial number, VIN number, whatever, and it turns out this is a stolen piece of property. So he goes back out to the sidewalk. This is a middle-class house. Looks like on the picture it's about, this is the sidewalk. The front of the house would probably be about 20 feet to the other side of that walk. So it wasn't a huge place. But what the U.S. Supreme Court said was, we already ruled on this in Florida versus Jardines. If you cross that curtilage, then you violated his right to freedom from unreasonable search and seizure. He said if you had this same extended motorcycle, and that motorcycle was inside the living room, visible through a picture window, it couldn't be any more protected than it was snuggled around the house in the curtilage. This has never been the law. This is stunning. So, you know, I normally say, get you a search warrant. Well, guess what? If it's under a tarp, maybe you don't have a proper cause to get a search warrant. The thing that it said was this: can you go up to the door and say we're having a national night out down the street? Yeah. Can you go and say there's a armed robber just robbed a home 3 houses over, just want to make sure everybody's okay? Yeah, you have the right to protect and serve, but if you cross that curtilage to gain information to criminally prosecute this guy, you had to have probable cause and emergency circumstances or a search warrant. So if you don't have probable cause, you can't get the search warrant. So the only option you've got is to add $1 billion to the budget and get 3 or 4 officers sort of to be there at the property for 3 days until maybe the guy comes back. It is, it's telling you, this is stunning. But whereas the Louisiana Supreme Court, 4 years ago, they got through saying, here's the house, and so you're driving by on the street, said anything that's put in the front yard there for anybody to see, there's no objectively reasonable expectation of privacy in that. That's what the Louisiana Supreme Court said 4 years ago in a case called the Strickland case. Now, as it is right now, the curtilage is just as protected as if it were the inside of the home itself. So I don't know what to tell you, except even if you had a PC, that's not enough. You'd have to have a PC and emergency circumstances. For example, the guy has on his motorcycle leathers and he runs out of the house and he jumps on the vehicle. Well, it's already proven he can go 145 miles an hour. That's known as the exigent circumstance. Yeah, you can move in on that. But otherwise, you'll either need to get a search warrant or maybe wait till the guy gets home and see if he'll let you up there voluntarily. It is a bad situation, but it is the law right now, and there's going to be some growing pains. The only thing good is there hasn't been a Louisiana Supreme Court on this yet, but these are 2 from the U.S. Supreme Court. The general rule is this: if the U.S. Supreme Court grants a bunch of rights to citizens of people in the United States, the state can't give lesser rights. That was the problem in the 70s, 80s, and 90s. The Louisiana Supreme Court, because our Constitution has the right of privacy in it, anytime they saw something that they didn't feel like it passed the sniff test, they said this violates the right of privacy. Which brings us to say, what's the third step coming up? What's the target? I hate to say it. Are you Miss Smith? I'm Officer Jones with Bossier SO. Do you mind if we talk a minute? May I come in? I think Knock and Talk's in trouble. There's not been a case that's thrown it out yet, but that's an inescapable conclusion from reading Florida versus Jardine that Mr. Langley talked about in his Collins versus Virginia case. We're just about through. Before we go, Judge Cox, you got anything to wind up?
Just good to be here tonight. You want to cover this with us right quick?
If you don't have anything.
No, it's great to be here tonight. Thank y'all for your attention.
We had a question, anything, Jane?
No, we appreciate what y'all do, and we look forward to seeing you next year.
And the actual marriage date was June the,
Watch it. Watch it.
it was in the 20s of June anyway. Sometime, we'll accept gifts all through the 20s of June.
Somebody's gonna be bad.
It was in 1970, I remember that. Okay, real quickly.
As your attorney, you have the right to remain silent.
I should have remained silent. Okay, look real quickly, please, on page 128, and we're gonna let you go. Here's a question we were just asked, it was written out. Ask the judge about sovereign citizens not giving their ID during a traffic stop. The actual, there's not a perfect answer for this, but the facts that I was given was there was a stop made because of apparently, it appeared that a light was out. Maybe there's just dust on it or just a dim light. Once the officer got up there, they saw that the light was actually in operation. Let me show you this. On page 128, you see A, B, and C under 215.1. Basically what that is,
That's Terry versus Ohio. That's what that is.
now turn over to the next page, 129. That came about 30 years after Terry versus Ohio. The D part, it's down about 12 lines from the top. It says, during detention of the alleged violator of any provision of the motor vehicle laws of the state, an officer may not detain a motorist for a period of time longer than reasonably necessary to complete the investigation of the violation, issue a citation for the violation, absent reasonable suspicion of additional criminal activity. And that is the law. That's what came out in 2015, U.S. versus Rodriguez, and 2017 in State versus Mantilla. The question was a 1 minute extension. The dog alerted either right at the end of the traffic stop or within a minute afterwards. You see, if the canine officer shows up during a traffic stop and says, hey Joe, it's been a slow night, you mind if I run my dog? No, that's fine. That's great. No further imposition on their privacy to do that. The dog alerts during the stop, that's people to search the car. That's Florida versus Harrison. This allegedly alert came about 1 minute after the stop, 45 seconds to a minute after the stop. What the Louisiana Supreme Court said was, well, it appeared that what went on was Mr. Mantilla reached under the seat to try to hide something. Everybody you talk to is going to have a different view of this. And believe it or not, a traffic stop can be made on reasonable suspicion of criminal activity. But that's a brief stop. That's not something normal. Most agencies have policies saying we're not going to make traffic stops unless we've got PC, because with PC you can go with it, it got 10 minutes to write that citation out or whatever. But in this case here, it's a perfectly valid traffic stop, but my opinion is once the officer looked and said, no, the light bulb wasn't out, it was illuminated, it wasn't illuminated real great, I think the stop's over right then. I think it's over. And what are the odds of coming up with this case with a sovereign citizen? I mean, you talk about somebody had a bad luck day to come up with this reasonable suspicion traffic stop, and it turns out the light bulb was working and a sovereign citizen. I will tell you this, regular traffic stop, you got PC, yeah, he's gonna have to provide some identification. What you do is don't get mixed up in what United States versus Carroll said in 1834. You do your job. And you know what, they're supposed to, the fact that you can accept a written agreement to appear, but if he won't sign the thing, then he has to be placed under bail obligation. He's got to identify himself if it's an actual valid traffic stop. But it's like, I don't recommend making reasonable suspicion of criminal activity traffic stops, but just remember, the clock is running. I'd say 5 minutes on a reasonable suspicion stop, 15 minutes on a PC stop. Everybody's got a different idea about it. But I think once the reason for the stop was clear, and the guy was, he hadn't exhibited anything else that appeared to be dangerous, I think he was free to go. And I hate to say that. This is Gene Drew. This is Judge Jeff Cox. I'm Harmon Drew. Adios. Be safe. Thank you.